So, as you know, we are organizing a series of programs as part of our Golden Jubilee celebration. We are organizing a series of third programs, third lecture as part of our Golden Jubilee celebration. We are organizing a series of steering programs, third lecture as part of our Golden Jubilee celebration. We are organizing a series of steering programs. We are organizing much pain in arranging the lecture series as well as in conducting it in time properly. Sir, we are much obliged to for giving us opportunity to attend these kinds of seminars. So, on behalf of all of you who are gathered through this virtual platform, on behalf of the college and on my own behalf, we welcome our principal to this August gathering. Welcome, sir. Next is our chief guest of today, Justice Basanth sir. He is quite known to each of the students, also each of the members of the bar bench, to the entire legal fraternity. Justice Basanth sir, he did his education at Malabar Christian College High School, Calicut, and later in the Malabar Christian College, Calicut. And sir, we are very proud to say that you are a product of Government Law College, Calicut. He was very much active in the campus and was also an office bearer of the college union at that time. He enrolled on 30th October 1973 and started his practice at Calicut on criminal, labor, and civil matters. He was attached to the office of K. Bhaskaran sir. He functioned as the secretary of Calicut Bar Association at that time. Later, he was appointed as the district and session judge in the year 1988, directly from the bar. Later, he was appointed as an additional judge of High Court of Kerala in September 2002, and as a permanent judge in the High Court of Kerala in September 2004. After retirement, he has started practice in the Apex Court, and now he is the senior advocate in the Supreme Court of India. As all of us know, sir is a versatile genius, a good lawyer, and above all a great orator, having his own views on all walks of life. He is having much interest in the welfare of our college, and we are fortunate to have you, sir, with us, and we are very happy to hear from you a great, profound speech, sir. Sir, welcome you to this gathering. Thank you, sir. So, last but not the least, the audience. They are the main factor in every function. So without the audience, no function will be successful. So on behalf of Government Law College, Calicut, and on my own behalf, I extend a wholehearted welcome to all the participants to this gathering. Thank you. Thank you very much. Sir, may I invite Basanth sir to deliver his speech, sir? Kumaran sir?
Principal, I will.
Oh, sir.
Presidential speech, I think.
Sir. Now I invite our beloved principal, C.V. Kumaran sir. He will be delivering the presidential address, followed by the speech of our guest, Basanth sir. Sir, please, Kumaran sir, please.
Thank you, Dr. Krishna Kumar. Honorable Justice Basanth, Chief Guest of the program, former members of faculty of the college, members of faculty and other staff of the college, other members of the teaching fraternity, students, research scholars, alumni, judicial officers, parents, ladies and gentlemen. It's a great privilege to all of us to have an alumnus of this institution, a former judge of the Kerala High Court, and a pride of our college to deliver this monthly lecture in the Golden Jubilee monthly lecture series. Justice Basanth was the student of this college in the first bench. His intimacy with the college is so well known among the alumni and the faculty of the college that I had no difficulty in obtaining his consent for his lecture, in spite of his busy schedule as a senior advocate of the Supreme Court. I had the privilege of closely observing the working of a working style of Justice Basanth as a judge of the Sessions Court, Principal Sessions Court, Talassery, as he then was. It was a model court and a lesson to all of us as to how a judge behaves and conducts the proceedings and manages the institution of judiciary with the decorum and the dignity. That is why he is still treated with respect by all the legal fraternity, not only in the state but also throughout the whole country. The topic of today's lecture is of great importance to the whole of the nation. With the spread of COVID-19 pandemic in the country has been reported, the life of all have undergone great changes. The lawyers and the legal profession is no exception. How it has affected the law, legal profession, working of the courts and the delivery of justice system is indeed a topic of immense interest to all of us. There has been various responses on the part of the judiciary to meet the challenges raised by the COVID-19 pandemic. Supreme Court the guidelines on functioning of the courts in hearing cases during COVID-19 pandemic issued in April 2020 and reported in 2020 volume 6 SCC to 686 and issued by the three judges bench comprising the S.A. Bobde CJI, D.Y. Chandrachud and L. Nageshwar Rao are both mentioned. And similarly, the Kerala High Court in a suo motu case have taken certain steps to ensure that social distancing is observed, that it did not affect the safety and health of lawyers, clients, and all other officials responsible with the running of these institutions and enforcement of the judgments and orders of the courts. And you will see that this outbreak of COVID-19 in several countries, including India, has necessitated the immediate adoption of measures to ensure social distancing in order to prevent transmission of the virus. The Supreme Court of India and the High Courts have adopted measures to reduce physical presence of lawyers, litigants, court staff, paralegal personnel, and the representatives of the electronic and print media in courts across the country, and to ensure continued dispensation of justice. Courts have set new ways to deal with the judicial proceedings without making physical appearance or meeting of the parties or advocates, judges, court staff, and other officers in actual courts, and substituted with the virtual proceedings by way of video conferencing. Courts responded with the situation in various ways, and that is the area that we will explore. And the use of technology, they has found judicial recognition, and so the Supreme Court by citing State of Maharashtra versus Praful B. Desai, 2003 judgments has approved the video conferencing system. And apart from that, even for enforcement, the physical serving of orders has been jettisoned by the Kerala High Court judgment that I have already mentioned. But it is not without a problem. The appearance of persons, especially advocates, before the courts, and familiarization of this technological advancements to lawyers were definitely certain problems. And we have seen in certain videos being shared that how some of the senior lawyers have responded and behaved, and how the Kerala High Court recently, speaking to Justice Devan Ravayandran, had warned or asked the clients as to the dressings and other things in video conferencing system. So, the did the system or has the system created by the courts and the accepted by the judicial profession succeeded in establishing or rendering justice to the people, and that will be explored by Justice Basanth in his speech. And with these few remarks, I thank you all for having come and attended this program. And with these remarks, I conclude my words. Thank you.
Thank you very much, sir. Thank you very much, sir, for the profound presidential address. Thank you, sir. Now let me invite our honorable guest of today's function, Justice Basanth sir, to deliver the speech. Sir, please.
Thank you, Krishna Kumar. Respected principal, ladies and gentlemen. The Calicut Law College, my alma mater, is on the verge of celebrating the Golden Jubilee. Matter of great pride for a person like me who was there when the journey started 50 years ago. I belong to the first batch of the Calicut Law College and have wonderful memories of the very simple, humble beginning that we made 50 years back. On this occasion, I gratefully remember the founders of the college. I remember at that time there was a Citizens Committee for Law College in Calicut. That is where it started. And then the principal, Professor Krishnan Nair, and your teachers, then Ramakrishnan Master and Prabhakaran Nambiar sir, they also came and we started the college with just one room, hardly furniture. My mind goes back to those days when it was a great challenge to establish and run the college. I gratefully acknowledge the contribution of all those founding fathers of this college. The college, during the 50 years of its journey, I am proud to say, has discharged its obligations eminently. This college has contributed to the first bench, the first court, the apex court of India by contributing one person. Several persons have been contributed to the High Court bench. We have had eminent leaders in the political life, ministers of the central government and the state government, politicians who matter, academia, the teaching fraternity who have done outstandingly well, senior advocates of the High Court and the Supreme Court, judicial officers at the district judge level and below, and above all, if I may say so, foot soldiers to the law army of India. We have several lawyers who have come out of this college serving the polity at grassroots levels in different districts of Kerala and outside. That really is the contribution that this college has made to Law India. And therefore, it's a matter of great pride and privilege for me to be part of this Golden Jubilee celebrations. I must say the pandemic has been a spoil sport. We had wanted the Golden Jubilee to be celebrated on a very great scale, but unfortunately, all things do not happen the way we want, and we have not been able to do that because of the pandemic. But then it's great that your present principal, Mr. Kumaran, and his team are trying to do their best in the given situation. Thank you very much for that, Principal Kumaran and his team. Law India today is engaged in a dialogue. Dialogue is a very, very modest term. It's a fierce dialogue. It's a fierce controversy that is going on. And the controversy is virtual versus, we always call versus, isn't it? Right through our legal terminology, adversarial, the versus appears everywhere. And so we call it virtual versus physical. That's a big controversy that is going on. I believe it's a good occasion for people, law men, from the law student to the highest in the hierarchy, to dispassionately dwell on the subject and find out the choice between the two. How good is the choice between the two? How do we choose? What do we choose? What is the discretion to be engaged? What are the pluses and minuses of both the system? How much can we accept? How much can we reject? I think it's a matter of great importance that a discussion like this ought to come. I congratulate the principal and his team for having chosen a very, very contemporary topic for my lecture today of virtual versus physical law India's conundrum. Well, every problem is a problem from the perspective. The perspective is important. From what perspective do you look at the problem? There are several ways of looking at this problem. I know primarily we look at it from the point of view of a lawyer. When I say a lawyer, you look at it, there are so many subdivisions of lawyers now for this controversial topic. You have a trial lawyer versus appellate lawyer. You have a perspective of the grassroots level lawyer to the constitutional court lawyer, be he a high court lawyer or a Supreme Court lawyer. We have a conflict of perception from the point of view of a very junior advocate, a novice in the bar, and a person who has put in some years of practice. We have also conflicts between perception of senior advocates and designated senior advocates, as also the others. I may loosely call the ordinary lawyers. Now, all these perceptions are important when you discuss the problem, but I would like you first of all to think, for whom does the bell toll? That's a very important thing. The law's problems are not to be perceived from the perspective of the lawyer and the judge alone. I believe there are stakeholders who are more important than a lawyer and a judge. As someone had said, war is too serious a business to be left to the generals. I'll borrow from that and say, law is too serious a business to be left to the lawyer and the judge. I believe civil society has a very important role to play in this debate that is going on of virtual versus physical. Let us not look at it from a small angle and look at it purely from the point of view of a lawyer of various hues and the judges of various hues. I believe we ought to understand for whom the bell tolls. And that, I have no doubt, is for the ordinary citizen of this country. I would call him broadly the seeker of justice. We have to look at the problem from the point of view of seekers of justice primarily. Of course, the others are also important. The system is a system, and all the members of the system are important, but primarily the perception must be that of the beneficiary of the system, the seeker of justice. This perspective is vital because when you approach the problem, I would like all of us to be dispassionate, be judicious, be reasonable, and try to approach this problem and not take sides from the perspective or the constituency from which I hail or you hail. Problem is much more important than that, and therefore we have got to understand that primarily our perspective has to be the perspective of the seeker of justice. Well, let me hope that we will be able to do it. Our system is one which, like any other, resists change. We don't want to change at all. Lighter vein, I would say the axiom of the system itself is stare decisis. Be where you are. The change is always resisted. We always like to do what we had done yesterday. The wisdom of the past always guides us. And therefore, we always find that it is difficult for this system to change. And if you observe closely, you find very little change has taken place also. I remember as a student of this college, we were sent to the Calicut Sessions Court. And then, as young students, when we entered the court, we found the presiding officer, a very serious senior judge of the court, sitting down and taking in longhand whatever the witness was saying. Mind you, I'm talking about 50 years back. About 72, 73 is the first time that a student of law, I went to the law college. We were shocked. In those days of technology also, we thought it was too much to spend the time of a senior judge or senior session judge in taking down all manually. Well, why should it be taken down? Can it not be recorded? Can it not be audio recorded? You know, this was a doubt which we young law students of those days felt sort of frustrated. Why such a long time? Every time a witness speaks a sentence, you take thrice the time for that to be recorded. How will we quicken the pace of justice if this is the way evidence is recorded? Was a doubt which perturbed my very young law mind at that time. I'm sure many of the students now must be going to the courts, and they must be really surprised that even today the same story goes on. In lighter vein, I used to say technology, science, and management are entities which have not yet got an entry pass into our court system. We lack terribly in management. We lack terribly in technological upgradation. We have no scientific advancement. We are not taken into our fold. With the result, we continue with the same old lost delays even now. Many of the available entities, facilities have not been made use of and woven into the justice delivery system, that we find ourselves not moving for past about 50 years in the matter of upgradation of technology. What is perhaps more surprising and more disappointing is that an idea has crept into the minds of all of us that there's nothing wrong in that. I heard when a discussion was going on the bench in the Supreme Court, someone remarked, for the last 70 years we've been going like this, there was no problem. How is it that the problem has developed all on a sudden? Well, I believe we must remind ourselves of one of the fundamental duties that we have. Article 51A, you know the history of that. It was not there in the original constitution. It came into the constitution in what is described as the dark period of Indian constitutional and democratic history during the period of emergency. But good that it came. And ultimately what 51AH, I'll tell you only 51AH. What it says is, it is the fundamental duty of you and me to develop scientific temper, humanism. Next is what is important for you in this context: spirit of inquiry and reform. Spirit of inquiry and reform. Well, you and I are duty bound as citizens, as teachers, as lawyers, as judges. We are bound to develop the spirit of reform. Charity must begin at home, and it's very important that we devise methods by which we reform our system and not be content and be happy with what we already have. When I'm trying to discuss the topic of virtual versus physical, it's important that we have both these. One, a perception that we are not going to look at it from any sectarian constituencies, but we are going to look at it from the larger interest of the seeker of justice, for whom the system exists. Secondly, it is important that we are not content with what we have. We must have a spirit of reform. We must develop a spirit of reform when we approach and try to answer this question. The pandemic has been a harsh misfortune for the whole world, for human civilization, for India and our judicial system too. It has been a harsh misfortune for this, but I would think that it has brought with it a train of opportunities. A long train of opportunities it has brought with it. Well, I heard someone in lighter vein say that the world history has been divided already into two. Before Christ BC and after Christ AD. It has been divided into two. Today the pandemic demands that we divide the after Christ period, AD period, further into two, before COVID and after COVID. The world is so different from what it was. When the virus struck the world, struck the human civilization in February, March 2020, finally when it came. Now when it came, it has really divided history further into before COVID and after COVID. The world, the human being, the human civilization have all transformed beyond recognition now. And it is only natural that our system, the judicial system, the justice dispensation system, has also got certain opportunities with that. When the Prime Minister of India declared the lockdown, complete lockdown, and wanted all of us to sit at home and not come out, there was a great casualty that was going to happen. The law had to sleep. The law had to idle. The law had to hibernate. How were courts going to function? Can the republic function without a court? All the lawyers, judges are all sitting at home. There is no possibility of the court assembling and interacting. So what do we do? I believe the ingenuity of the Supreme Court was seen at that point of time. Your principal referred to you that decision. The Supreme Court said, we are invoking Article 142 to meet the extraordinary situation. They invoked Article 142, and by an order dated 6/4/2020, which the principal referred to as in the citation, they passed an order granting legal sanctity, which was not there hitherto. Till then, it was not there. Yes, Prafulla decision was there, which permitted one witness to be examined as by video conferencing. But conduct of a court by video conferencing without physical assemblage was unknown at that point of time. That is where I salute the Supreme Court of India for its very innovative ingenuity of having passed that order dated 6/4/2020, which brought to reality that even during these difficult times, law cannot sleep. You have heard, even when the battles go on, the law cannot sleep. And when the battle against the virus was going on also, the Supreme Court declared, granted legal sanctity to the functioning of the virtual courts. That is where, in the Indian scenario, forget about Praful decision for some time, because Praful, as I told you, only permitted virtual examination of one witness because of certain circumstances. But the virtual courts, as you and I today know, came into existence only with that decision by the Supreme Court. Now, we functioned as such for about 18 to 20 months now. When the very existence of the legal system was under challenge, we tried to salvage it by inventing this possibility of a virtual court functioning, so that at least the emergent functions which the courts had to do could be performed through those virtual courts. We have traveled 18 months down the line. Virtual courts have served us. Virtual courts have ensured that law does not sleep. Virtual courts have ensured that the injustice perpetrated is not left to be suffered until the sun comes up again and the virus disappears. It has made it possible for courts to function. And now, as COVID, we hopefully, I don't know, even now there's the threat of the third wave coming in, and the reports from the Europe doesn't appear to be very happy. But whatever that is, at least in our country now, for even take away Kerala, we find there is a great hope of the pandemic receding. And as soon as the pandemic is receding, there is a clamor. And the clamor is restore status quo ante. We are very fond of that expression. We are very fond of the expression status quo, and if possible, status quo ante also. We want things to be restored to its position prior to that order of the Supreme Court in April, so that we will disband the virtual courts and maybe get back to the situation prior to that order. That is the dispute going on. Today, that is the dispute that is going on throughout the lengths and breadths of the country. People taking strong sides on either side. Should we discontinue this laudable experiment which kept us alive during the pandemic, which ensured that Law India does not abdicate and say, sorry, I can't do anything. The virtual courts helped us to keep the system living and at least attend to emergent duties and responsibilities during this period. Now the clamor has come that I would like to discuss with you today, perhaps, what are the major faults, major inadequacies of the virtual court system that is happening now, which according to me is important. In making a choice, it's better to be devil's advocates, try to look at the negative side of things and see how much is this experiment is prone to fail. And that is where I think there is no much of legal research done yet. We'll all have to accept. We don't have documented research papers which would tell us the compare with the functioning of the courts before the physical courts before the pandemic and the virtual courts after the pandemic. There is no authentic data to compare. It's difficult because prior to the pandemic, all the physical courts were functioning full swing. But after the pandemic, when the virtual courts came, they have been coming in bits and pieces. The Supreme Court itself started initially with one bench, expanded it to 3, expanded it to 5, expanded it to 8, and now maybe perhaps all the 13 courts are functioning virtually. But during this period, there's no possibility it would be puerile to compare statistics and come to any conclusion. One, we don't have authentic data. Two, we do not know what would be the situation if all the courts function virtually as it is perhaps happening in the Supreme Court today. We don't have data. You know that. See, earlier we were not functioning in full swing. Even if there were the possibility of 14 courts, only 3 or 5 were sitting, and even they were only attending to very emergent matters. And therefore, comparison of statistics would be a very futile, non-productive endeavor, according to me. We should not be tempted to do that at all. Forget about the statistical inadequacy of disposal or whatever it is. We can look at the way the virtual courts function and see what ails the system. Now, the virtual court started functioning in about April after that order. I find a very useful paper by the Parliamentary Standing Committee. Those who are interested in research must certainly work on that. The Parliamentary Standing Committee, led under the leadership of Member of Parliament Bhupinder Yadav, submitted a report to the Chairman of the Rajya Sabha and the Speaker of the Lok Sabha. 103rd report of the Parliamentary Standing Committee for Personnel, Public Grievances, Law and Justice. My search showed me that this is the only authentic paper that we can perhaps get on the functioning of the Indian virtual courts during the pandemic. But that also, you please realize, this was submitted in September 2020, after the court started, after the idea of the virtual courts was planted by that order dated 6/4/2020. At best, it gives only 5 months review of the working. But it's interesting. Anyone interested in the study must go to that document and try to learn, try to understand the concerns that address them and how they dealt with the problem, how they wanted to look at the future of Indian court system and how they thought the virtual courts can help in the ordinary times also, not the virus times, in the peace times also, how the virtual courts can help the system to function. They analyze and they find, and I completely agree with them, that there are 3 major areas of deficiency for the functioning of virtual courts in India. First one, they identified, and I fully agree, is the problem of access. The lawyer as well as the court do not have the infrastructure of laptops and other equipment necessary to have a video conferencing. I have an online hearing. Many of the subordinate courts, even today, lack the infrastructure. Not many, I would say most or almost all. The subordinate courts, when I say that, I'm talking about the courts at the grassroots levels. They as well as the lawyers from the Mofussil courts or the village area courts or the rural courts also do not have the equipment or the infrastructure to do this video conferencing. Both do not have adequate infrastructure. This is the first problem. This is the first problem. And there it is suggested by them that it is not as though we have to give up the experiment for want of such infrastructure. It must be possible for us to furnish infrastructure so that legal provision will update itself. I mean, once you know that it has to be done, the lawyer gets the infrastructure, lawyer gets the requisite competence, and he will do that. But the state will have to spend on the infrastructure or the courts. Now, a lot of ideas are suggested. E-Seva Kendras at all centers, whereby lawyers can go to those centers and access the courts. They are all suggested, but the fact remains that this is a major deficiency that we'll have to fight when we think of perpetuating the virtual courts. Improve access. See, invest money in the infrastructure or the subordinate of all the courts. Now, the Supreme Court and the High Courts have mostly been invested with, investments have been made, and to a certain extent, the infrastructure has been developed. Now, we may have to go to the next stage of equipping the subordinate courts, the rural courts, with the necessary infrastructure. That is a major difficulty. Whoever raises objection to the virtual court system is justified, I would say, in raising an objection that we don't have the infrastructure, and therefore the problem of access as the first point is raised against the virtual court system. Second is the connectivity problem. Well, the whole of India is not yet connected over the net. Maybe the urban areas are much better connected. Now, the rural areas are not connected, and therefore it is important that the connectivity issue is addressed. So one is the access issue, second is the connectivity issue. Well, I don't have the time to give you all the effort that have been made to square up this deficiency. The E-Seva Kendras, as I told you earlier, the what is that? The mission to expand infrastructure of the courts, which is going on, that will also help. And maybe we are traveling nearer to the ideal situation of connectivity for all. Third, I think, is the skill deficiency. Many of us lawyers do not have the skill. We are so alien to modern technology that most lawyers find it very, very difficult to handle the technological equipment, acquire the technological equipment to do that. Well, here again, the solutions are suggested. The solution easily is perhaps we must introduce in the legal curriculum from the colleges, we must introduce the competence in ICT for the students. It is at that level that we have to start. Maybe you will have to increase the number of papers or substitute some of the papers and make sure that in the law course there is adequate provision for ICT competence. Well, for the existing lawyers, maybe Bar Council will have to step in. They will have to have sessions of updating the lawyers on technology in order to get over this deficiency in skill. All these three problems that I told you, that I repeat, the problem of access, want of infrastructure, lawyers not having the necessary infrastructure, they will have to invest and then get themselves updated. The connectivity issue will have to be addressed, and the skill issue will have to be tackled by the profession so that we will be competent to take up the responsibility of a conversion to an ICT modality, ICT regime, which will make it possible for the courts to do it. I am conscious of the fact that many eyebrows will be raised now, and you will say, easy for this man to come and say this, but when are we going to achieve this? The options are very, very limited. Modernize or perish is the watchword before the Indian judiciary. If you can't modernize, if you can't technologically upgrade yourself, technologically be equal to the task before you in the coming years, perhaps we will never be able to. I may also warn you, the young people who are coming to the profession are all much higher, better than the older generation like me and ICT technology. They are coming in. Unless we update ourselves, be assured that we will be thrown to the dustbins of history, dustbins of the profession, and others will steal a march over you. So upgrading yourself, equipping yourself technologically is the need of survival. Survival of the fittest. Darwinian theory applies even now. If you can't update, you will not survive. That's why I said modernize or perish will be the mantra in the profession, and it is better that lawyers, old and young, start reading the writing on the wall. It's important that we update ourselves, and all the three inadequacies that are referred to are there, are not to the ideal level. The access problem, the connectivity problem, the skill problem are all staring at us, but maybe they are not problems without a solution. It's time that we look at solutions and find out whatever we can do for ourselves, we can do, and maybe wait for the state, the government, the judiciary to spend on infrastructure. At least I would tell you, I can vouch on that. The technological upgradation that have taken place in the Supreme Court and the High Courts, which are being now monitored by the E-Committee in the Supreme Court headed by Justice D.Y. Chandrachud, they are doing a wonderful job. If you would kindly read the pamphlets, newsletters that come from them, you will understand how much of investment is being made to upgrade the system and to make it equal to the task before it in the coming years. It's time that we start doing it up and not simply say that I don't want a VC at all. Many people find it very convenient to say, I don't want VC at all. Why? I'm not used to that. Why? I'm too old to upgrade myself. I repeat, if you do not upgrade, what's going to happen is you'll be thrown to the dustbins of the profession. You will not survive. Survival of the fittest, and the others will take over, and we will be left in the lurch, unable to meet the requirements of the times. New problems call for new solutions, new innovations, and we have to live up to that, keep abreast of the developments, and therefore the lawyer community would do well to remember that it is not possible any longer to turn your back on technology and say, we are all not used to it at all. Last 70 years, it has been functioning very happily, and that is where we are. We don't want to improve. Maybe we are taking a very huge risk in having that sort of an attitude. Well, the next problem that is raised, I know, is that the concept of an open court is lost at all. You all know what the open court concept is? The Anglo-Saxon courts say it's part of the transparency, the very culture of the system, that trials, hearings take place in open court. There is no secrecy. There is transparency, except when the court says that a certain proceedings shall be held in camera for specific reasons. Courts of the Anglo-Saxon system are open. What do you mean by courts are open? Does it mean Tom, Dick, and Harry can walk into the court? Yes. Theoretically, yes. Theoretically, any person can walk into the court and see for himself what is happening in the court. That is the concept of an open court, which is one of the fundamental virtues of an Anglo-Saxon court. The court must be open. What do you mean by open? Well, the court is open. Tomorrow, when the Supreme Court opens for physical hearing, can everyone walk into the Supreme Court and say that Anglo-Saxon courts are open and therefore I also want to be in the court? Sorry. The openness is proportionate to the facilities that are available. It may not be possible for any court at any time to permit all those who want to see the proceedings to come to court. Even when the entry to the court is regulated, it continues to be open. The openness is not lost because there is regulation of the entrance. Because of want of infrastructure, because of the inadequacies of space, because of the inadequacies of conveniences, courts may always say, we will regulate entry into the courts. What I am trying to tell you is, regulation of entry into courts does not detract from the concept of openness of the court. Let's understand that very clearly. Let's understand that very clearly. Merely because one person is denied access to the court, denied admission to the court to watch the proceedings, it does not mean that the court is not open. The court is still open. You will find interpretations of the Supreme Court on that. It is said that evidence shall be taken in the presence of the accused in a criminal trial. In the presence of the accused. That expression was interpreted in Prafulla and others to say, presence does not mean physical presence. It is enough if he has access to know. So that the court remains an open court, even if it regulates entry into the courts. And it is with that that I want you to understand whether the physical court will be any more open than a virtual court. Today, a criticism against the virtual court is it is not open. That is one of the problems. Well, I believe that even in the physical court, we are not admitting everyone. In fact, you will know that is one of the fundamental rights of the media to come to court. Every individual in this country is entitled to know what is happening here. You cannot admit everyone into this court. And therefore, I say that admit me, the media men, admit us, the media men, so that we will project to the world waiting to know what is happening in the court. You know, there was a controversy between lawyers and media men, and we thought media men need not be admitted to court at all. Well, that was not accepted. Media men are coming into the courts not for their own rights, not in exercise of their own rights, but they are exercising rights on behalf of the multitudes who have a right to come to the court, whose entry you are regulating. And therefore, the concept of open court will still be served if the substantial number of persons concerned are given access to the court, are given entry into the courts. Well, how many persons do you admit into a court? Given the inadequate infrastructure of all courts from the Supreme Court down to the local magistrates court, you can see that at the most in the Supreme Court, in many of the courts, there is no space even for the lawyers. And therefore, how do we admit people? Well, the visitors gallery is there where some people, mostly token presence of persons, can be permitted to enter and watch in order to ensure that the fundamental attribute of the court being open is kept intact. How many ordinary people can come to a local magistrate's court to witness the proceedings? How many can the presiding officer permit? Well, if that be so, if you can admit only 20 persons into a court, in a virtual court, if you can admit 20 or 50, is it not sufficient to call it an open court? Well, let not jargons trouble you. Sometimes it is said that the virtual court will not be open. Well, that is why I wanted to analyze this in detail and tell you that if, as a matter of fact, we are able to admit reasonably the same number which we would admit into the physical court and grant permit admission physically, if that number is permitted to go into the virtual court, that court is not any the less an open court for regulation of entry to witness, to see what's happening in the court. Well, I believe that we are going into an era of live streaming, right? Many of the courts have already accepted live streaming. Live streaming, according to me, is not an indulgence carried out by the courts, but it is part of the recognition of the right of the people to know what is happening in the court. The ordinary citizen has got a right to know what is happening in the court. That is transparency. Well, and therefore, if all of us cannot be admitted to one court, if a certain number of people are permitted to enter the virtual court to watch the proceedings, what is the problem? Think about it. Think about it and find answers. What is the problem if today, out of the 1,000 people who want to come, we are admitting a sample of 20, in the virtual court also, out of 1,000 people who come, we are going to admit almost a similar number. And therefore, only thing is technology has to be upgraded. That is all. Well, you can have a visitors gallery section for a virtual court where people will only be able to see and hear what's happening. They'll not be permitted to participate, as we do not permit people in the visitors gallery to participate. We don't allow them. In the physical court also, we are not allowing them. And so there's no problem. See, we need not give them visibility in court. They must be able to see the court, and they must be able to hear the court, and that would be sufficient satisfaction of the concept of openness of court. And therefore, I cannot subscribe to the version that virtual courts will be not open and physical courts will be open. That is something that I have to say on the question of openness concept. The courts to be open concept that we have. Live streaming, if it is going to be permitted, you can perhaps increase the number of visitors gallery and permit more and more people to see this, and maybe permit them to record it. What is secret in what's happening in the court? Why are we reluctant? What a person is permitted to see and hear, let him record and do it. Give out to the world. What is wrong in that? More and more courts are accepting that, and then live streaming is now permitted. If live streaming is permitted, those in the visitors gallery can certainly be permitted to disseminate it to the world who are waiting outside the courts, honestly, fairly, without malice. Of course, that is gone. That goes without saying. Now, don't ask me what do they misuse. There are laws are powerful enough to ensure that those are not misused. Even now, a person can sit in the court and on the slide take the recording of what is happening in court. Well, a judge dozed off one day and somebody took a mobile phone picture and sent it around in the media, media, and therefore social media, and therefore such things happen, and there are sufficient built-in mechanisms to prevent that. Now it is said that what happens in Kerala High Court, somebody came without a shirt and somebody sat there and started drinking something. Well, this is technology that the technical expert will tell you very easily. We can provide systems in such a way that those in the visitors gallery will not be seen in court. They can see the court, but they will not be seen by others. And the visibility will be given in court only to lawyers and parties who are appearing. Others will not be given visibility. So that the possibility that people may come without shirt, people may come may chew pan, they may drink, they may do this. Now somewhere they said somebody was patting on the back of a maidservant. That will also come in the... Well, all these are imaginary problems which we are unnecessarily thinking that can stand against a virtual court system. Well, the interest of live streaming will also be satisfied. According to me, once you give out the signals to the visitors gallery and permit them, if necessary, to use it for transmission also, the need of an extra video streaming will altogether vanish, and this should be more than sufficient. You can increase the number in the visitors gallery, because the bandwidth required may also be much limited, because he will only see and hear, he will not be seen and heard, and therefore more and more number of people can also be admitted. This is an area of the expert, but I'm definite it can be done. You can increase the number of visitors so that maybe we can have more people visiting than in the physical courts today. We can have more people in the virtual courts than people who struggle to find their way into the court, rubbing shoulders with the lawyers and parties in the courts. Even that is possible, and therefore, these are not insurmountable problems which can stand against a virtual court system. It can certainly be permitted. Now, next is an advocate's problem. Not a selfish problem of the advocate, but I remember I had this doubt. Now, I'm an old man, and therefore at the age of 62, I went to the Supreme Court to start practice again. And then I thought all my skills of advocacy of persuading another would have dried up. And still you try. And as you try, you think, okay, I can try, I can manage, I can always try to do it. May not be as well as the others do, but still I can do it. And therefore you start doing it. Well, when the virtual court system came, I thought I was at a blind alley. I thought I had come to an end, because we usually say, I argue a matter looking at the judge. The judge's expressions are important. I am arguing a proposition. How does he receive it? Is he receiving it? Is he inclined to hear me more on that? Traditional advocacy in a physical court includes all this, undoubtedly. When I argue a point, I look at the twinkle in the eye of the judge and I decide whether I must go further with this point or not. Will it be a waste of time? All of you lawyers who are practicing would show, whichever level you are practicing, this is the lawyer thinking on his seat. Lawyer taking a call on whether I must go further with this point or not. And therefore, I thought I will not be able to adjust to this new system where I see my judge on the screen only, and I'm trying to argue before him, not knowing what response it makes. You know, there is a story, a hunter went for hunting, and he did not get anything. Finally, when he was returning, he fired 2 shots and said, when the rabbit comes, let it be hit. Like that, sometimes what we think is, I am arguing, I do not know whether the judge is catching this point or not. This is like the hunter, you fired a couple of shots in the air, hoping that it will hit the rabbit when it comes. But I tell you, believe me if you will, this is all incorrect notions that we have. This is basically a fear of the unknown. It is basically a distrust of the unfamiliar. Last 18 months when I started practice as a lawyer in the virtual courts, the initial reluctance and diffidence is slowly giving way, and more confidence is being acquired that after all, there is no significant difference between the virtual advocacy and the physical advocacy. I know quite a lot of my friends who say there is a world of difference, but with great respect, I disagree with them. And I would say, yes, some marginal difference will be there. I'm not saying it's not there. It's not there. With every change, some differences will come, and we will have to live with that. We'll have to learn to live with that. And therefore, that is not important. Some difference will, of course, be there. But to say that my advocacy will get dried up if I have to do it virtually, I'll be able to do it physically only, is the response of a diehard who does not have the spirit of reform within him, which 51AH mandates. You ought to have that. And therefore, I would with very great respect would say that many of these things that we have, the apprehension that we have is the fear of the unknown, distrust of the unfamiliar, and it need not really be there. As you go forward and forward, you will find that you adapt to a new type of advocacy, slightly different, of course. I'm not trying to deny the obvious. It may be different, but you get used to it. Well, I repeat this story also. When I came to the Calicut courts, they used to say about 10 years back, the lawyer would start the argument, a sessions case, at least 2 days he will argue. Now, if anyone takes up more than 1 hour, you can see the judge's eyebrows getting more and more wrinkles. Well, times have changed. Then they used to argue by saying, it is the singular good fortune of my client that my client can stand trial before an erudite judge like you. Today he'll say, shut up, come to the point. Right? See, advocacy has changed. It has changed. If you're not able to transform yourself, keep with the times, you will be discarded. Many lawyers have found themselves unable to adapt to the changes and they have got discarded. They have got thrown out. The ability to adapt is a very important weapon in the armory of a lawyer. And he will do that. The competent will do that. There's no doubt about it. Well, there is one unfortunate section which I think will be worst affected by the virtual system. You have the facility to file online filings. Smart young lawyers will hereafter not depend upon any clerk at all. He will sit in his office and file the petition himself. He will correct it. He will do everything. Service of notice also on the computer. He will do that. And therefore, I'm afraid advocates' clerks will be harsh hit by this transformation. You've got to accept it. You've got to understand it. Well, gone are the times when the advocate's clerk used to be a partner in your professional work. Even today, an advocate's clerk offers administrative support to you, not a professional support in the strict sense, in the very strict sense. Advocates' clerks at the time when I joined the bar in 1973 were persons who prepared the petitions, who prepared the claims, who prepared the written statements, who prepared, even gave the draft issues. They would only show it to the lawyer and then file it. Now, all those functions are not there for the advocate's clerk, even today in a physical court. The role of the advocate's clerk is getting reduced more and more, and he is becoming only an adjunct to the administrative efficiency of the lawyer, not the professional efficiency stricto sensu. And therefore, I'm afraid the advocates' clerks as professionals might be losing out in this race. My only statement is it is unavoidable. Even today, it's happening. Even today, the role of an advocate's clerk 50 years back when I joined the profession is entirely different from his role today as an advocate clerk of today. No lawyer depends upon a clerk to file his pleadings, to draft his pleadings, nothing. It does not happen now at all. He affords only administrative support to the lawyer, and therefore, I'm afraid the concern of the advocate's clerks is very, very real. Their role is getting to be diminished more and more. And therefore, it is important that we make them partners in administrative functions of the lawyer and do not throw anyone out because of the transformation in the nature of work. Lawyers have to be considerate. They have got to make sure that this fraternity of advocates clerks are adequately protected and made use of for the administrative support which every lawyer should have in the discharge of his work. Well, there is one concern. I don't know how fair I will be in making this, mentioning this concern. Many of the lawyers feel that our work will be lost. Sorry, please understand me. I'm also a lawyer today. Take me into confidence. I'm saying the Supreme Court lawyer feels that if the if the video appearances are permitted, more and more High Court lawyers will come into the Supreme Court. The High Court lawyer feels that if the video conferencing is permitted, more and more District Court lawyers will come to the High Court. The District Court lawyer feels that if the video conferencing is permitted in the District Courts, more and more Mufassal Court lawyers will come into the District Courts, eating up our work. This is a concern. Maybe a real concern. I will not deny that. Maybe that's a real concern. I have no quarrel with that. But I again ask you, for whom does the bell toll? That's a fundamental question. Well, today, please understand the difficulty of the seeker of justice who wants to come to the Supreme Court. The distance, the language, the expenses all deter him from coming to the Supreme Court. Please get statistics from the Delhi High Court, from the Punjab and Haryana High Court, from the Shimla High Court. Even for a small rent control petition, to get 6 months' time to vacate, they come to the Supreme Court. Whereas for a litigant in Kerala, he must think twice, thrice, 4 times, 100 times before he decides whether I should go to the Supreme Court to try my luck. Language is different, environment is different, climate is different, and therefore I cannot do it at all. If you would permit a High Court lawyer to do e-filing and argue the case himself, how many lawyers would choose to engage a person like me in the Supreme Court rather than his own lawyer who has studied the brief already in the High Court? Don't think or look at it from my point of view at all. I am irrelevant. I mean, the lawyer in the Supreme Court is irrelevant. More important is the person, the seeker of justice. If you can improve his access to the court by permitting e-filing, part of a virtual court regimen, if you can permit his lawyer to argue before the Supreme Court, well, look at the amount of money, time, energy, resources that he is saving. Look at the amount of middlemen that will be eliminated. I repeat, I am not looking at it from the point of view of a lawyer at all. Look at it from the point of view of a seeker of justice. That is what I think is important. If, as a matter of fact, mostly, I think the trial court lawyer is a friend in need for the client. I always call the trial court lawyer a friend in need for the client. The higher you go, the more the distance between the lawyer and the client, and then he does not necessarily become a friend in need. Sometimes he looks at you as the one who exploited by misery. That's the difference in conceptualization. Mostly, I find the trial court lawyer is and ought to be a friend in need for him, because he has so many contacts. He knows him either directly or through others. He knows him, and therefore, if I have a good trial lawyer who has dedication, who has competence, who has commitment, will I ever engage another lawyer to argue the appeal? Just think of it. Will I ever engage another lawyer? If my lawyer is competent, is dedicated, committed to me, will I engage? So the loss of opportunity for one lawyer is the gain of opportunity for another. I am looking at the legal profession as a whole. I'm not trying to subdivide them. It's harsh. I know it's harsh. There's no doubt about it. Many of the young lawyers have spent a lot of efforts to set up practice in the Supreme Court, and it may lead to some loss of work for them. I have no quarrel. I'm accepting it. It will happen. There's no doubt about it. It has to happen. But it happens for the good of the seeker of justice. And in the bargain, another lawyer is benefited. I'm not worried about lawyer A is benefited or lawyer B is benefited. My final conclusion is the profession of law is not losing at all. A instead of B, C instead of B may happen. But the profession of law is not suffering at all. And the advantage is many, many fold. Kindly look at, I don't know how many of you had experience of taking a matter from the trial court through the district court, through the high court to the Supreme Court. Think of the plight of a client and how he will view the system. Don't get angry with me. You know, those lawyers at various levels, please don't get angry with me. I'm just trying to want you to introspect. Well, all good things arise out of introspection. Please introspect and find out what will be the plight of that seeker of justice who is given all these advantages: reduction in cost of litigation, reduction in the time expense part of it, reduction in the travel, reduction in the expenditure. Look at all that. To engage a lawyer, he has to go all the way from his local court to the district level to the high court level to the Supreme Court level to brief him. Well, it's very important that we understand. I repeat again, the system does not exist neither for the lawyer nor for the judge, but for that seeker of justice. And if we understand that principle well, this objection or the lawyer not being able, suffering will perhaps vanish altogether. Well, that also I'll tell you. Supposing a lawyer, a client wants to engage a reputed lawyer in the high court to come to the district court to argue his matter. Now you have to go there, you have to take him by car, you have to get an accommodation for him, he has to give up all work there and come here. The virtual courts would ensure that he sits in his office and he is able to do your work and his high court work too. So expenses on him will also get reduced considerably on account of this. Viewed from the point of view of the lawyer community as a whole, there is no loss. Viewed from the point of view of the litigant, the seeker of justice, there is a hell of a lot of plus points. And I would think, please don't throw away this experiment because the lawyers are likely to lose, according to me, a wrong perception. Along with this, I'll tell you one more thing. Filings have dropped. There's a general feeling among the young lawyers. I speak to them, I see them often. There's a feeling that the filings have dropped. Please, sir, the filings have not dropped because of the virtual courts. Filings have dropped because of the pandemic. Many people are not able to do the needful. Why did the Supreme Court extend the period of limitation? Supreme Court extended the period of limitation, accepting the fact that many people will not be able to come out of their houses and file litigation. The litigation not being filed is not equal to the litigation reducing. It's only getting postponed. It will be filed. Now, during the pandemic, all the district courts, all the high courts have the rates of disposals have gone down miserably. If there is no disposal in the high court and the district court, how will there be work in the Supreme Court and the high court? So that please don't jump to conclusions merely because the total filings have dropped. It is no indication, it is not a malady of the virtual court system. It is a malady of the pandemic. And therefore, please understand that that is also not a sufficient reason to throw away this experiment. Well, I have some, I do not know how many of you realize that. The total time spent in courts, I would say, colossal waste of time in the corridors of the court can be avoided. Well, I know I keep waiting and waiting and waiting for my case to be called. Some days it does not come up at all. I sit from morning till evening hoping that the matter will come up. The one before me is so elaborate, my matter doesn't reach. Colossal is the waste of time in the corridors of courts. Call it man hour or woman hour. the loss of hours in the court, waiting, colossal waste of time can be avoided because I sit in my office and do my work. I can take up other work. I can take up studies. I can research. I can do a lot of productive work than waste my time in the corridors of the court, waiting, and waiting. Well, this is a malady which afflicts every center. And I think there is some light at the end of the tunnel if we have the virtual courts where, yes, I will have to wait, but I wait in my office table here. I know when the case is called, the laptop comes to me and I go to the court. Look at it this way, what a lot of advantages. The time spent on the roads. Think of the time spent on the roads. Think of the pollution that take place because of the unnecessary running of the vehicles. Well, think of the optimization of use of time. Time is the most precious of all commodities in life, isn't it? Well, if I can profitably utilize my time to do other work or research or to advance in this work, what a lot of advantage it will be. Forget about all the other things of wastage of petrol, air pollution, this, that, etc. I think the way I look at the positive side of the virtual courses, that will also be helpful, right? Well, there is a great dispute going on as to whether the pace of justice can be quickened. Well, proverbial is the law's delays. Whether we can quicken the pace of justice is a moot question. Both opinions are possible, but I believe we have got to understand that timeliness can be achieved a lot by the virtual court system. Not far away is the time when the courts in the virtual court system is going to give you specific time for your case. Well, if you get a time, your matter will be taken up at between 10:30 and 11. The waiting time is reduced so considerably. Slotted hearings is the future, and therefore a virtual hearing, you can certainly expect a virtual hearing the court to give you slotted times for hearing your matters also. At the moment, it is too premature to find out whether the pace of justice has been quickened or not. But seeing the way courts function, it is my opinion, I say opinion, that the pace of justice can also be quickened, made faster by the experiment of the trial court. There is one more aspect that I would like to say. We keep saying that the representation of women in the judiciary is very poor. You have heard it, isn't it? Why are you worried about the representation in the judiciary alone? What is the representation at the bar? Tell me. Are you 50-50 at the bar? If you are not 50-50 at the bar, what is the justification for the clamor that judges must be 50-50 at the 50-50? What is the justification? Do we give our women a chance to continue in the profession? Well, it's something which we must very. I heard some very serious judge talking about this, and it impressed me that this is a point which we have to consider. Getting held up in the court from 10:30 in the morning to 5 in the evening is something which the Indian woman, given her responsibilities, I know many of you young men are sharing the chores of home also. You must be not my generation, but your generation is doing that. But still, the traditional roles are assigned to the women. Once she becomes pregnant and she becomes confined to home, many practitioners stop their practice. They are not able to take up the cudgels thereafter. If you want a general neutral system where both genders are adequately represented, and at the bar and on the bench, we must have roughly equal proportion of the female half of humanity. for which you have to give them opportunities. Well, the virtual system will empower them, according to me. Many of the ladies I find are more competent than all of us put together. Many of them, right? Their competence, every day when I read the papers, I look at it. Look at the graduate rank holders, more than 60% women. Look at the postgraduate, more than 60%. Entrance examination, more than 60%. And what are we? Well, we deny to them a lot of opportunities, therefore blocking their entry to various avenues of service. Well, I believe virtual courts could be one little step to give them equal opportunity to be competitors at the bar. You like it or not, they may be able to do it. And I think this might give them the opportunity which we are looking for, which they are looking for, and which we are bound to give it to them. All right, my time is running up. I think I must stop now. Well, I must also tell you, look at the amount of money, taxpayers' money, that have been pumped into the system during this pandemic to bring up virtual courts. Well, I don't want to speak in terms of crores and thousands, but you all know, please read the relevant details. Huge money has been pumped into the improvement of infrastructure of the courts. Because the pandemic is receding, if you are going to give up the experiment altogether, what has happened will be, it will be a classic case of throwing out the baby with the bathwater. You can't do that. This is the taxpayers' money that has been invested for upgradation of the judicial system. You have to exploit that investment and make maximum returns out of it. For which also, I think this possibility of status quo ante prior to 6/4/2020 has got to stop. In terms of the taxpayers' money invested, we have got to derive returns, and for which also this experiment, which does not suffer from any major disadvantages, may have to continue. Now, just a couple of points and I'm done. I agree with you that the trial courts will find it difficult even today to function VC, right? We do not have the infrastructure at most of the rural, the village, the Mofussil courts. We don't have the infrastructure, nor is the infrastructure at the appellate or the High Court or the Supreme Court sufficient to do this, because arguments can be advanced by anyone sitting anywhere, but the witness will have to be brought to court for cross-examination, or centers where the requisite protection of data protection, etc. will be there. Otherwise, you can't examine a witness. You can't allow the witness to sit at his home and examine him, because prompting is there. He's looking at documents which are not permitted are there. All those cannot happen. So maybe, I'm saying maybe, we may have to continue with this experiment for a certain types of cases only. Well, take away the trial courts from the VC court experiment, leave them to continue as it is till such time that the infrastructure is improved. Even the trial court for arguments, you can use VC, but examination of witness, etc., you may have to, well, slowly introduce this in areas which are permissible, where you can profitably introduce them and make sure that we upgrade ourselves. Well, introducing it all on a sudden in all courts may carry with it a lot of problems, but a lawyer, if he is used to, accustomed to arguing over VC for some time, will definitely be prone to think, why not I do cross-examination also on this? Then he realizes that after all, it's not that impossible or that difficult. So maybe I would think that we can certainly think of starting the VC experiment, continue the VC experiment at the Supreme Court, the High Court, and the appellate courts, subject to the rider. What is the rider? That in an appropriate case, the court may say, no, I want to hear it physically. That, of course. There may be peculiar circumstances in each case, and even there, hybrid hearing can be introduced. Please see if you can get access to the Supreme Court, how beautifully the hybrid arrangement is working. It's not impossible. It's possible for the hybrid experiment to work, so that until we have completely satisfactory infrastructure, etc., the trial courts can continue physical, right? Of course, in them also, part of the process of arguments of a petition where evidence is not required can still be done VC. The high courts or the appellate courts, the Supreme Court, there definitely we can continue the experiment, which is, according to me, has worked well. There is no inherent difficulties in that. That can also work. And therefore, let this work. Give this an opportunity to work. Do not discontinue the system halfway through after all that we have done, after all the effort that we have taken. Please don't throw it away like that. Give it a chance, because the whole world is digitalizing. The whole world is turning electronic. The whole world knows the advantage of technology. Well, a mother here today is not very happy that her daughter, not unhappy that her daughter is married away to the US. Why? She looks at the WhatsApp call and then talks to her. That is how life is improving. Well, why should the courts alone throw away this advantage that we have? Communication has become so easy. I just pick up the phone and talk to whomsoever I want, anywhere in the world. We are living with the advantages of technology and improving our quality of life. Should the quality of judicial disposal alone suffer because some of us do not want to advance? I know quite a number. I was also belonging to that tribe who says, I use my phone only to call and receive calls. You must also be having such people, quite a number of such people with you, who say, yes, I have a telephone, I buy the most modern one, but I make calls and take calls. I don't do anything more than that. Well, this is a traditional, conventional reluctance to go the way of technology. It will change. It has to change. How many days it will take for each person to change is the only problem. I find many of them who said, I'll use the phone only to call and return a call, now taking selfies, taking photographs. I see that. It's inevitable. Technology has a great magnetic attraction to it and will make people comply and use it. But the initial reluctance has got to be, we have to get over that. And that is where I would very emphatically say that this virtual court experiment is taking us nearer to a knowledge society. This virtual court experiment is taking us to an era where the scandalous delay in the judicial process can perhaps be taken away. It's taking us to a time where the client will have less expenditure, more convenience of choosing of having a lawyer of his choice arguing the court wherever he wants him to argue. We are heading for a time where colossal waste of time in the corridors of the courts not like me. There are many who are very, very competent, whose time is money, whose time is value. That need not be wasted on the corridors of court. There are many, many, many advantages. I would be very reluctant. Nay, I would caution the legal fraternity against squandering this opportunity, which the pandemic has presented. We did not opt for it. The pandemic offered it to us on a golden platter. The Supreme Court responded with ingenuity and accepted it and gave it to us. So please, I would again summarize and say, think of limiting it to not to examination of witnesses or what is strictly called the trial processes. Avoid that. Try to introduce hybrid systems. Make sure that this continues in the superior courts, and wherever the court feels and wherever the counsel feels for valid reasons that there must be a physical hearing, Concede that to him. Where is the problem? Concede that to him. Introduce hybrid hearings to the extent possible. This is the way we can go forward. We must equip ourselves to meet the challenges of the future. And in that event, in the choice between virtual and physical, maybe the choice will be virtual for the future. Thank you very much.
Thank you, sir. Thank you, sir. Thank you very much for your thought-provoking and enlightening speech. Your speech here opened the eyes of most of us who are having our own perspectives on the ICT-enabled justice system. Still, there may be questions, worries, and doubts in the minds of most of us, some of us at least, about the virtual court experiment. So those who are having any doubt or anything to ask to sir, please raise their question.
I'll tell you, this doubt is a very bad word, Nobody is asking me for any doubts, nor do I have the answers for the doubts. No, if you put some problem, we can think together and try if we can solve it or accept that it cannot be solved. For every webinar, when they say ask doubts, I want to caution. I don't have the answers for all your doubts at all. I'm only thinking along with you to find out if we can find an answer to that problem. Right? Thank you.
If anybody wants to put forward a question, they can do that.
Who's Murali has raised a hand?
Yes, sir.
Yes,
sir.
yes.
Mr. Murali has raised hands.
Good evening, sir.
Yeah.
I'm from the first year of 3-year LLB batch from GLCK, and I really want to thank our principal, sir, beloved principal, sir, for providing this opportunity. And I'm sure everybody in this forum can't agree more with the valuable message that you passed on. And actually, I could feel that that a person of your stature is speaking my mind, because I'm also a litigant in the family court. So I've seen the problems being faced by litigants, especially in this COVID era. And you have really given a valuable message, despite the fact that you're now a senior advocate in the Supreme Court. So I'm sure, sir, in the process, what I feel is that the seeker of justice is being sidelined in the process for reasons better known to some particular group. But you have reinstated the need for the legal fraternity, especially the lawyer fraternity, to again go back to our basics and think the purpose why we are there. It is for the benefit of the seeker of justice. So you have really highlighted that, sir. I'm very much happy that you have brought this, and I really look forward to that day when this will become the norm. And like every change being resisted, and we have, and the time and history is a testimony to the fact that despite all that, we would evolve and we would slowly adapt. And I'm sure, and I dream of that day when this will become the norm. And by the time people like me, we pass out and we start practicing, I'm sure we will be reaping the benefits of this, sir. Thank you so much, sir. I'm really privileged to have you in this session, sir. Thank you so much, sir.
Any more question, please?
Sir, my question is that, sir, what is the gravity of confidentiality that is involved by using the international platforms like G Suite, etc.? Sir, the confidentiality is preserved or not?
Very good. See, it's for an expert. Really, it's in the area of an expert to answer this. I may tell you what I have gathered from the experts. We are using various platforms for our purpose now. Recorded versions we've retained, and if you can ensure data safety and security, I don't think the experts say there is no real problem of that. Not to say that there will be no hacking ever. No, even the Pentagon details are hacked, and therefore it may be very difficult for me to assure anyone authentically that there will be no hacking, there will be no cyber bombing, etc. But I am given to understand that it's possible to preserve, to protect against data piracy and data safety. It's possible to protect. Yes. That's all that I can tell you. I'm not an expert to tell you more about this, but please understand that our experiment shows we have been using Zoom platform is being used by many. Google platform is being used by many courts. Now, to rule out that may be difficult, as I told you. Even the most guarded the the systems are hacked sometimes, and therefore I may not be able to do that. But in how many cases do we have such very vital, sensitive, secret, confidential information available in a case? So in order to give up this experiment for that, well, I accept the assurance by the expert that it is reasonably safe, right? I accept that human endeavor can never make it absolutely foolproof. I accept that also. I also take note of the fact that what is the amount of confidentiality that happens. Maybe in such a case, you can go, instead of going virtual, you can go physical. Well, supposing there is some sealed documents available and someone feels that it should not be given, it should not be translated into digital stuff, the original paper document must be maintained. That's a fit case that you can ask for physical hearing. For me, the problem is very simple. If such sensitive information is involved in any case, well, very good. That's a very fit case where the litigant should seek and the court should accept the plea for a physical hearing. Right?
Thank you, sir. Thank you, sir.
Okay, thank you very much, sir. Back to Kumaran, sir, for concluding remarks. Sir, please.
Did somebody raise a hand? What is that?
Yes, sir. Yes, sir.
Okay, let
Yes,
them
sir.
take that.
Let that be the last question.
Okay, okay.
Yeah, sure, sir. So one more thing that I read somewhere regarding this virtual hearings is that there is one school of thought which says that there may be some overzealous advocates or lawyers who might want to showcase themselves by these virtual hearings, and thereby they want to progress in their careers and get wide publicity. So what is your thoughts and
Very good.
take on this, sir?
Fantastic question. Sometimes I hear it on the other side. They say the exposure in court is lost, and therefore the merit may not be recognized. This is the converse of that question, that somebody else may. Well, what is the amount of exposure that you get in virtual as distinguished from physical? Exposure in that court, right?
Yes,
That exposure you have even in a physical court,
sir. Yes,
right?
yes, sir.
Have I made myself clear?
Yes, sir.
See, what is the amount of exposure to sell yourself, to advertise yourself? What is the opportunity that you get in a physical court distinguished from a virtual court, or vice versa? You can only advertise it among those present in the court. That you can do it virtually and physically. And you can go to another court, just as physical court, you can move from one physical court to the other virtual court. If you are good enough, you sell yourself. It may be attractive. You may sell yourself, but there's nothing wrong in that. In doing what is permitted, in arguing a case beautifully, all the present may see you, whether you are in the physical court or in the virtual court. And therefore, either way, it doesn't matter, is what I feel.
Thank you, sir. But I think, sir, what they're trying to hint at is like there may be some top lawyers. We already know some top lawyers practicing in Supreme Court where they would be charging humongous amount of money. So I think probably a section of the legal fraternity, they're very much skeptical about this, thinking that it will give more edge for those when compared to the normal lawyers who are at the grassroots level.
I'm just asking you, that is possible in a physical court and in a virtual court, right?
Yes.
Virtual court also, when all of us sit, we are as though we are in that court. We move to another court, then there also the same lawyer appears. That happens in both. That's what I'm saying. Well, an argument against what you're saying is, If I have my local lawyer who's competent, I am not going to waste my money on that. Well, I've always felt a good court is one where the lawyer appearing should not make any difference. Right? A good court. I was a judge. I've always wanted myself to tell myself, in your court, forget about the size, the volume of the lawyer that is appearing, be confined to the merits of the case that you have. I think most courts would do that only. And if you have a lawyer who has studied the brief well, in whom you have confidence, he will argue the case for you. Why waste money on some unknown lawyer because he's appearing in some other case, many other cases? But competence is always recognized. The whole legal profession is built on competence. Proved competence will improve your stakes in the profession. There's no doubt about it.
Very well, sir. Thank you so much.
Thank you, one and all. Then to Kumaran sir for his concluding remarks. Sir. Kumaran sir.
We are much obliged and indebted to Justice Basanth for his wonderful speech, which has examined the different aspects which we might not have thought about before we entered this platform.
Yes.
And we would like to invite Dr. Ambali Vyas to propose the vote of thanks.
Namaste. Most respected Chief Guest, Sri Basanth, our Principal, Sri Kumaran CV, beloved Professor, Dr. N. Krishna Kumar, other dignitaries online, and my dear students, a very good evening to one and all. It's a great honor for me to give away vote of thanks to the most respected personality, the Senior Advocate of Supreme Court, former Judge of High Court of Kerala, Sri R. Basanth. As Krishna Kumar sir and Kumaran sir mentioned, we are fortunate today to have Sri Basanth on this platform. On behalf of Government Law College, Kozhikode, I would like to express my sincere gratitude to Sri R. Basanth for his online presence and the contribution on the topic virtual versus physical law, India's conundrum. He made his point very clear that our judiciary require more application of science, technology, and management, especially in this pandemic situation. This year, GLCK had uplifted as research center, and Sri Basanth sir opened a new window to the world of research by giving a new topic to research, functioning of physical and virtual court, a comparison. Borrowing his words, the main problem we face today regarding virtual courts are access issues, connectivity issues, skill deficiency in the area of information and communication technology, absence of open court, and some of lawyers' problem. Also, he made his point on gender equality in all avenues of services and hybrid trial court system to implement. I thank Sri Basanth for the wonderful speech and enlightening us in the new area of virtual court. Once again, thank you, sir. I extend my gratitude to Sri Kumaran sir for the detailed presidential address pointing the importance of topic we discussed today. Thank you, sir. Also, to Dr. N. Krishna Kumar for the wonderful welcome speech and the introduction to Sri R. Basanth. Thank you, sir. Last but not least, all the personalities who have made their online presence to make this session a great success. On behalf of GLCK, thank you all.
Dr. Lovelman also needs to be thanked.
Oh.
Yeah. Sorry for not mentioning him. Thank you, Lowell, sir.
I am part of GLCK.
He is a part of our family.
Thank you, sir.
Then you should thank me too. Yeah.
Thank you, sir. Thank you so much. Hope we can wind up the session now.
Okay, sir. Okay.
President may declare that.
Thank you very much.
Thank you, sir. Thank you.
President may please declare that.
നല്ല സെഷൻ ആയിരുന്നു സാർ, എക്സലന്റ് സെഷൻ.
Okay, excellent session. ഞാൻ വിചാരിച്ചതിനേക്കാൾ എത്രയും
തീർച്ചയായും സാർ, നല്ല സെഷൻ.
Kumaran sir, thank you so much, sir, for organizing this, sir.
Sir, in
മുരളിക്കറിയാം ഇനി ഒരുപാട് ഇതേപോലത്തെ സെഷൻസ് വരും മുരളി.
ഇനിയും വരുന്നുണ്ട് കേട്ടോ.
Sure, sure. I
Thank
look
you, sir.
forward.
Thank you.
Yeah.
നല്ല സെഷനായിരുന്നു. Thank you, sir.
It was so timely. It was so timely. And there were
Yes.
wonderful points also. Yeah.
Yes, yes. And
എല്ലാ
it
areas
is
cover ചെയ്തു. That is another
and
thing.
it is very apt, you know, what he said actually, that, you know, see, this virtual session happened because of this technology. He is sitting in Delhi and we are all sitting here in Kozhikode. And this happened because of, and this very, very apt.
Yeah, the points
The
regarding
faculty
distance,
and the PTA has
expense.
to think about presenting a plaque or a memento to him for having participated in this program and delivered this lecture, I think.
Definitely, sir.
Definitely, sir.
Definitely,
That
sir.
will be valuable for
Yes.
from
Yes.
his album later.
Thank you. Okay, thank you. We will do it.
Have a nice week
Thank
to
you,
everyone.
thank you, Dr.
Have a nice
Jubilee, for thanking everyone.
Okay then.